The purpose of the video is to give you an idea of what the comparative law course is about and why it makes sense to study comparative law. There are really four reasons for studying comparative law. The first is to give you a sense of perspective. You are exposed at law school basically to courses in the common law tradition rather than the world of the civil law. The civil law is a much larger legal system and a much older legal system, and most of the countries of the world subscribe to it. Having the perspective of knowing where civilians are coming from is a very useful thing to have. The second reason for studying comparative law is that it is enormously practical in the sense that many of your clients may well be from other countries, or you may have to deal with lawyers from other countries. If they're trained in the civil law, you can at least have enough of the vocabulary to be able to ask intelligent questions of them and to understand where they're coming from when they answer questions. This is especially true for anybody who wants to practice in an area like Miami, which is plainly an international city. And many of my students have told me that after taking my course, they are now able to understand why a number of their foreign law clients were asking certain kinds of questions and requesting certain kinds of services be performed for them. A third reason for studying comparative law is that it gives you a real sense of history. I have found that most of my students in recent years have very little sense of history. It's a course that takes you back at least to 450 BC with the first legal code, the 12 tablets. And we trace certain legal institutions all the way from 450 BC right up to their modern evolution. And a fourth reason for studying comparative law is that it is a great deal of help in transnational litigation. Just recently, I did an amicus curiae brief for a large multinational oil company, which is seeking to avoid having to pay an $18.5 billion judgment against it in Ecuador. And the reason I wrote the brief, pro bono by the way, for the oil company was because the judge in Ecuador was bribed to render the decision that he rendered, and the expert's report upon which it was based was fraudulent and forged. And now they're trying to enforce this judgment in a number of different countries. And one of the arguments that was put forth by a group of law professors from Canada was that on appeal, the errors at the trial level had been cured because every appeal in a civil law system is essentially a trial de novo, and therefore, even if there were bribery and other procedural misfunctions at the trial level, the Court of Appeals decision cured them. I am enormously skeptical of that position, particularly because the appellate court reached exactly the same result as the court below and failed to consider any of the evidence of bribery, and failed to consider the fact that the expert report upon which the damages were calculated was a forged document. All of this is under litigation right now before the U.S. Court of Appeals for the Second Circuit, and it's going to be interesting to see how it all comes out. But comparative law has a great deal of practical application in the real world, and many very important verdicts depend upon one's ability to understand where foreign legal systems are coming from and how they interact with our own legal system. So that is the purpose of, or the multi-purposes of the comparative law course.